Good evening, this is John Milburn for Laws 12063. This is Advanced Statutory Interpretation and Drafting. We're into week 12 of Term 2, 2019. Thank you very much, Nadine, Nicole, for joining me this evening. As I think you've done pretty much every time we've convened on a Tuesday evening at 7 o'clock. So thank you very much. And for those of you that have watched the recorded sessions every week, I really do appreciate you doing so. From the work that I've seen so far, the standard in this cohort is very high. This is the kind of unit where those who are really dedicated to their craft will undertake the study. And it's a pleasure for me to be able to deal with people that are providing very good work. Now, tonight we're not dealing with anything directly accessible. It's only accessible indirectly in relation to assessment number 3, which is where you provide some indication of the work that you've done, work that you've completed during this term. So as a reminder, you need to upload your work for both assessments 2 and 3 tomorrow. That is the 9th of October 2019 by 11:45 p.m. So Wednesday evening, and the cutoff for both is short, the 12th of October 2019, which is the Saturday. So if you produce your work and upload it on time, no penalty, and then you're done. If you produce your work and upload it between the 9th and the 12th, I will deduct 5% for each day of late submission. And if you have not submitted your work by 11:45 p.m. on the 12th of October, then I will award nil for that work that should have been uploaded. So please upload your work. If you have any questions about that, please let us know through Q&A or send me an email. All right, well, tonight we're dealing with wills and contracts. This is really important from a practical perspective. So for those of you that intend to actually practice in law in a solicitor's office primarily, will find this information contained in week 12 material highly relevant and useful. So in this topic, as we see from the study guides, our aim is to learn how to plan, draft and execute a will, same for a contract, to ensure that the intentions of a testator are given effect to the greatest degree possible, to avoid ambiguity and poor drafting. And the penalty for ambiguity, for poor drafting, is that the contract or will that you prepare might be deemed uncertain. And note the contra preferentum rule, which provides that if you draft something, any ambiguity will be essentially construed against the party that intends to rely upon the ambiguous term when drafting that material. So do have a look at the keywords in the study guide and note ambulatory, which is a word or a document that has a meaning that might change over time. And we dealt with that quite a lot in statutory interpretation. Those of you that may have worked with me in statutory interpretation in the first instance would have come across that, as we have done in this unit, particularly in the context of drafting the material that you've drafted for assessments 1 and 2. Parole evidence is also important. You would have seen that in contract law, and that is where verbal representations made by one party to the contract may or may not have an effect on the written terms. And the presumption about that which is in writing having importance. So have a look at those terms, understand them, and they're just a few that you might use. If you're still using your toolkit from back in Introduction to Law, then these are the sorts of things that you might add to the toolkit progressively as well. All right, so let's get on to some substance. Wills and powers of attorney. And I will ask a few questions as we go, just to keep things alive. So when we talk about estate planning documents, there are really three documents that we might consider from a drafting perspective, or from the perspective of offering for a client to consider. So if a client says, I'd like you to assist me with estate planning, then of course we'd think about wills, number one, powers of attorney, number two. Can either of you think of the third document that we might consider within that context? Sorry to put you on the spot. Those of you watching as a recorded session, please try to identify that. Pause if you need to. All right, well, the answer I'm looking for is advance health directives. Now, a will, of course, is a document that is signed by a person while they're alive with capacity, directing someone, the executor, to undertake certain work, the administration of the estate, in order to deal with things like funeral and the assets and liabilities of the estate. Of course, the will in itself has no binding effect or legal effect while the testator is alive. Conversely, the power of attorney is a document that again is signed when a person has capacity to understand the nature and effect of the document, but the intention is that it is either effective immediately, which it can be in relation to in relation to financial matters, or something that comes into effect at a future time. So that might be in relation to financial matters at a certain date, or on a certain occasion, for example, if I'm overseas, or in relation to personal health and optionally financial at a stage where the person is no longer able to make their own decisions. So if you're signing a power of attorney, it's usual to provide someone, the attorney, with power to make decisions for you as the principal for financial matters, personal and health matters, but the latter two, health and personal, can only take effect if you lose capacity yourself as the principal. If you provide someone with power to make decisions for you in relation to financial matters and do so while you're capable of making those decisions yourself, then effectively you have two people that are able to bind you, you and your attorney, or your attorney. But of course, an attorney who's making decisions with a person who has capacity does so, must do so very carefully, and probably wouldn't do so without the express instructions of that person at the time. Sometimes people say, well, can I have a will and power of attorney in the one document? Effectively, you can't do that. And the reason is that the will takes effect upon death, has no effect before death, and the power of attorney has no effect at death, but only has effect while the person is alive. So they're dealing with different things. I hope that makes sense. Now, the testator is an individual, not a couple. Sometimes people come to you and say, I'd like you to draw a will for the two of us as a couple. You can't do that. So you have individual wills always. There is another thing that sometimes people do, and that is that they sign complementary wills. In other words, they're mirror images of each other's, which is fine, but wills are always revocable. So people can change the wills whenever they like. One thing that you could consider if a client say, we want to make our wills and we want to make them binding and we want to have a commitment that neither of us will change the will, you can enter into a separate contract, or have them enter into a separate contract, which is mutual wills. So it's a mutual wills agreement. Even then, like all contracts, one party might breach the terms and sign a fresh will. If they do that, then whilst there may be some consequences, the fresh will will take effect over the original will, where even though there was the intention not to change it. I hope that's not too confusing. If you have any questions, please feel free to unmute the microphone or use the chat facility as we go. So when we're drafting a will, the first thing that we need to do is revoke any prior wills or testamentary instruments. Now, when we talk about an instrument, we're really talking about documents, aren't we? But a testamentary instrument is a document that has effect upon death. And usually we're talking about wills and we're talking about codicils. Oh, one thing I forgot to mention, I mentioned briefly advance health directives as the third document within the context of estate planning. An advance health directive is a little bit like a power of attorney, but in that it can incorporate a power of attorney, but it's essentially a direction. As the name implies, it's an advance health direction. It's a direction in relation to one's health made in advance. So essentially it would say, if I lose capacity to provide health instructions, then in these particular scenarios, here is my instruction to the medical team that is treating me. I hope that makes sense. So it's a direction about one's health, but made in advance. So it's the third type of testamentary document. So Nadine says, would that include orders, instructions not to resuscitate? Exactly. In practice, I would often find that people would say yes to a will, maybe, but probably to a power of attorney, and only limited circumstances to an advance health directive. Two reasons for that. The first is it's quite, well, three really. It's a very cumbersome document and you have to involve your medical practitioner, your doctor in that process. So there's a bit of work to be done, a bit of expense and a bit of time and commitment to it. The second is that it is a document that in a way is redundant, because if you lose capacity, if you trust the person or people around you, then they can make those decisions anyway. So you don't have to have the advance health directive for a decision to be made. It's just that you're not making it, someone is making the decision for you. And the third reason is that most of the population don't necessarily have strong views on the matter, or if they have, they voice them to someone that they can trust. A possible exception is those people that don't believe in blood transfusions. So for religious beliefs, they may say, I really do want an advance health directive because I want the peace of mind of knowing that I have taken control of that very important health decision that may become necessary down the track. So the third thing is, if people have strong views or beliefs, then advance health directives are useful. Let's go back to wills and drafting wills. So the first thing you need to do is revoke former wills or codicils. We don't use codicils much. When I started in the early 80s and when I studied in the 70s, codicils were quite a big deal. Can anyone think of why codicils were quite a big deal in the 70s and early 80s, but they're really not very often seen at all now, and we haven't really seen codicils in a widespread manner for 20 or 30 years. Any idea? Again, sorry to put you on the spot. The answer I'm looking for is simply technology. So when I started, for example, we were using typewriters and typewriter ribbons. It was a big deal when the first word processor came into the office, which actually allowed you to memorize a ribbon of typing, use a few keystrokes, and it would automatically go into the document. So rather than having to retype physically an entire will, it was the custom, if you wanted to change one part, for the drafters to make a codicil, which was effectively an amendment to the will saying, I refer to my will dated the 10th of January 1971, I change it in clause 3 by doing this instead of that. I hope that makes sense. But now, of course, we would simply just scrap that old will and we'd start again. It takes no time at all and it's much neater. When I say it takes no time at all, I'm talking about the technical side of things. I don't mean to suggest that the process of drafting the will should be taken lightly or undertaken quickly, quite the opposite. Now, when you're preparing something which provides for the alienation of property, do you remember that term from property law? We need to guard against the indefinite breaches of the rule against remoteness of vesting, which is the good old rule against perpetuity. So you'll recall from property law days that the general proposition is that the perpetuity period extends to the lifetime of people alive at the date of creation of the trust and 21 years from the date of death of the last survivor of those people. We remember the term life or life's end being. So the question is, how do we deal with that from a drafting perspective? Because there's some evidentiary issues. Now, I'm going to do a couple of things here. So my intention with this next section is twofold. It's firstly to remind you about the rule against perpetuities and also to give you some heads up as to what we're going to be further discussing tonight, which relates to good drafting technique. So let me share the screen and you should see on your screen now Section 209 of the Property Law Act, which is the power to specify the perpetuity period relevant in relation to dispositions made where there is an intention for the disposition to be made at some future time. And I'm talking now in the context of a will. But you'll see the heading there. What does this mean? It's really difficult drafting. Now, see over for an English translation is my version of what Section 209 says. And I must say in advance, I'm not necessarily sure that my version is that much easier to understand than the original section. Partly that's because this is a difficult concept. But if you're drafting a will or a trust deed and there is an intention for the vesting to be at some stage in the future, you must at least consider the rule against perpetuities. So if the period of the perpetuity exceeds 80 years, then the general position at law may apply. So what was the general law? The general law was, as I mentioned earlier, that a trust must not extend beyond 21 years after the date of death of an identified party alive during the period when the trust was created. At the end of the 80 years, or earlier if the trustee determines, the trust will vest, it will cease. And the trustee will at that time gather in all the trust property, convert it to cash, pay a distribution, or pay in specie distribution to beneficiaries, and the duration of that trust may be extended or shortened if all agree. So that's my version of Section 209. And I'm saying property law, but of course this would have been dealt with in trust law. So you may have worked with me in either of those. I've been involved in both property law, but probably more so in trust law at this university. I'll stop the share now. Any questions over that difficult topic of perpetuities? And I'm sorry to burden you with that. You thought, if you've already studied it, you thought it was gone and never be seen again. And here it is cropping up in advanced statutory interpretation and drafting. Okay, so once we've identified that, the next thing we need to consider in a will is the executor. In the old days, we used to talk about an executor and an executrix. Thankfully, a lot of that sexist language is disappearing, and we just now talk about an executor. But there are some choices to be made. When drafting a will, do we choose one person, or do we choose more than one person? Or do we choose a company or some form of entity to be the executor. If we choose more than one person, do we then appoint that or those people jointly, meaning they can both make the decision with equal authority, or do we appoint them jointly, when I say jointly and severally, so jointly means together, my apologies, or jointly and severally, meaning either or both. Or do we appoint them successively in the order named? That's pretty common drafting technique. So it might be, I appoint my spouse, but if my spouse is unable to act as my executor, then I appoint my child or children. So that's what we mean by successively in the order named. The next part of drafting a will is the scheme of the distribution. Different ways of doing this. In practice, we use residue clauses all the time, very regularly. I know if you're theoretically drafting or considering wills, you may think, well, doesn't that breach the rule against perpetuities? It doesn't really. From a practical perspective, it doesn't. But when you're considering the drafting of a will, you need to consider outstanding debts, paying for funerals. You don't need to specify everything precisely. You can talk about all debts or any debts. And you don't have to specify individual assets. You can talk about all of my assets. Just a couple of tricks though, when you're talking about distributing assets for a testator, there are a couple of things that don't technically form part of the estate, but you might think they do. So you need to take care firstly with joint tenancies. You'll remember from property law days that where we have a joint tenancy, the law of survivorship applies. What that means is that should one of the joint owners of property pass away, then the law of survivorship kicks in immediately and the property therefore at law vests in the survivor. And that happens theoretically and practically before we even look at the will. So by the time we get to look at the will and look at the assets from an administration perspective, that jointly owned asset is gone, hasn't it? Because the law of survivorship kicked in, it's now somebody else's property, so it doesn't form part of the estate. From a drafting perspective then, you perhaps need, and from prudential perspective, inquire of your client, do you own any property, and if so, with someone else, and if so, do you own it as joint tenant? If you do own property with someone and it is a joint tenancy, do you wish to sever the tenancy in some way or another so that it doesn't go to the other person? Now, the second thing that you need to be careful of, and Nadine, you've hit it on the head, you've got the right answer, superannuation. Technically, superannuation is not part of your estate because it's funds maintained in a trust situation where the trustee, the superannuation fund trustee, controls it. Now, you can take some steps to direct that trustee by providing a binding death nomination to some degree as to where those funds should go. But theoretically, superannuation funds don't form part of the estate. And likewise, you need to be a bit careful with proceeds of insurance. So thanks for Nadine for identifying that. The next thing in a will is some funeral instructions. Now, again, it's a little bit of a trap. They're not formally part of the will. They're more an expression of a wish or even a hope, but ultimately the executor has the choice of how to deal with your remains if you're the one drafting and signing the will. So you can say, my intention is, I want my remains to be, my body to be cremated and the remains scattered somewhere. But the testator can say, no, I'm not doing that. I'm going to bury you. That's their prerogative. And then, of course, we have the formal signing of the wills, which you might consider. All right. In terms of technology, just a couple of points in the notes, I think. Chatbot wills are starting to pop up. So the chatbot is, of course, where you're dealing with an automated computer system. And there's an interesting article referred to, I think, in the text from where the ABC provided some commentary in relation to the advent of technology in wills. And we're used to the concept of referring to extrinsic evidence when we're dealing with statutes. You can do the same thing in the construction of a will. So an authority there is a recent case, Roberts against Pollock, which is 2019 QSC 184. Very soon, we're going to leave the topic of wills and we'll go into contracts. But before I do hope that you've had an opportunity to read an excellent article, even if you speed read it, an excellent article by Thomas Word called A Brief for Plain English in Wills and Trusts. It's a 1980 article from the University of Richmond Law Review, and it is reproduced with permission in the Moodle site. So please read that. I'm just going to extract some of the important material from that. And while I do, to ensure that I'm properly acknowledging the source of this material, I'll share my screen and you should see the introductory page, the cover page for this article. So in this article, Thomas Word in the Law Review raises some really good points. Now, I loved the introduction. I'll just read it into the record, as we say. We lawyers thrive on disagreement, but on this we are unanimous. Clients are precious, hard to get and easy to lose. A typical citizen asks a lawyer's help, but seldom, to buy a house, face a traffic charge, or make a will. The will client comes emotionally charged. He deals with his most personal concerns, his family, his wealth, and his death. A will is the most personal of writings, save perhaps a love letter. And yet we respond to our clients' simply expressed wishes about who gets what with a bewildering instrument that is, typically, too wordy and redundant, flooded with lawyerisms, unfamiliar words and inactive verbs, and poorly organised. A will should be written for the client's eyes. Of course, it must be sound technically, but it need not be written in legalese. By applying English principles in our wills, indeed in all of our drafting, we can respond to our clients in language that they will understand. We will also improve our instruments technically. So what are some of the things that we do wrong when we're drafting wills? Well, number one, a key issue is it's too wordy, it's too redundant. Let's take this example. Last will and testament of John Quincy Doe. And this is far too much. This is very much the way we used to write in the 70s and 80s. I, John Quincy Doe, now residing in the city of Richmond, state of Virginia, and of course Thomas Word is an American writer, being of sound mind and memory, do hereby make, publish and declare this to be my last will and testament, hereby revoking, annulling and cancelling any and all my wills and codicils hereinbefore made by me. And that's 49 words. Would not the following have done just as well, says Thomas Word. There it is. I, John Quincy Doe of Richmond, Virginia, make this will and revoke all earlier wills and codicils, and that is 17 words. At the top of page 473, the writer does excuse lawyers to some degree, but by giving some reason why we started to write in the way we did. The penchant for redundancy, a string of words with the same meaning, has a base in history, says Word. At various times, the English had two languages from which to choose, and I've changed his wording slightly to suit the way I prefer to write, to read. So I'm not reading this exactly, I'm paraphrasing. At first, it was the Celts or the Anglo-Saxons. Later, the choice was between English or Latin, and still later, between English or French. So lawyers began using a word from each language, joined together for a single meaning. Thus came legal tautology. Free and clear, which is from the Old English frio and French clair. Other examples, full and complete, good and sufficient. So that's why we started to do these things, but it doesn't explain why we continue to do them today. So the conclusion is excellent. Recent cries for plain English in legal documents and government regulations suggest plain English is something new, but it's not. Good writers and good lawyers have practiced and advocated it for a long time. Wills and trust agreements are consumer documents. They can and should be written in plain English. So I really like the way that Thomas Word writes his article, and the points that he makes are very valid, very good. Thank you for your patience. You're hanging in there with me. I'd like to move on to contracts. Before I do, any questions in relation to the drafting of wills? The first major topic for tonight. All good? All right. Let's go on to contracts. Now, one of the problems with contracts is the use of standard forms. It can help, but it can also hinder. It can provide some traps, so be very careful. Typically, when we're dealing with a contract, we're dealing with something that conveys property. So some issues for the buyer, and there's some issues around property and performance of price, consideration and deposit, risk and insurance, mechanisms for breach. I'll need you to read those from your notes. But when you're drafting a contract, you need to be very careful about the contra preferentum rule. In other words, an ambiguity in a contract will be construed against the person relying on the ambiguous term. I will go back and just fill in some of the detail. So firstly, buyer issues, purchaser issues. You need to identify clearly whether the buyer is an individual, more than one person, or a company or a trust. There's a very real commercial penalty imposed if you get it wrong. Can you think of what might be the basis of a commercial penalty, financial penalty, if you include in a contract the wrong name? Or instead of including a company, as the accountant would like you to do, you include the individual, John Smith or Mary Smith. Can you think as to what might be the financial penalty for getting it wrong? Nadine, you're spot on. Stamp duty or transfer duty, as we call it now. But yes, there is a very real risk of having to pay double stamp duty in those circumstances. Even if the first transaction is not completed, it is notionally a transaction that is dutiable, or legally it's a transaction that is dutiable, and therefore there is in fact technically two transactions. From the original seller to the incorrectly stated buyer is number one, and then number two is from the incorrectly stated buyer to the correctly stated buyer is transaction number two, therefore two lots of stamp duty. If two parties buy property, then at some stage or other, you need to consider whether that acquisition was made by them jointly as joint tenants or made by them as tenants in common. I mentioned earlier the law of survivorship that applies in a joint tenancy. It does not apply in a tenancy in common. And the process of moving from a joint tenancy to a tenancy in common is described as severance of the joint tenancy. Now, the second area, it relates to property, performance, and price. And really, when it comes to drafting a contract, they're the three key areas: property, performance, price, and you could add to that parties. If you've got all of those four Ps, odds are you've got an enforceable agreement. So you need to correctly identify the property or the performance of the duties and the price. You can do that by way of a mechanism in terms of the price if you wish. And there are, of course, you'll remember in property law days, some statutory requirements for a note or memorandum of writing to exist in relation to the contract for the sale of land. Refer to sections 11 and 59 of the Property Law Act, Queensland, 1974. The next issue is consideration and deposit. With the deposit, there's a few tricks here. Number one, it can be paid immediately. It can be deferred. It can be paid in multiple steps, or it can be a combination of all of those things. Do take care with the extent to which the deposit is paid. If it goes beyond 10% in relation to real estate, that contract automatically becomes an instalment contract, so therefore different rules apply in relation to it. So if you're drafting a contract, go beyond 10% if you have good reason to do so and you are aware of and prepared to take into account the instalment contract regime. Now, deposits don't have to be in cash. A very important alternative to a cash deposit, particularly for commercial properties where the value is considerable, is some sort of bond, a deposit bond, which is provided by the bank as a commitment to pay in circumstances where there's a call made upon that bank. Another one is risk and insurance. Usually the risk stays with the buyer, and usually the buyer will need to take out insurance straight away. And then typically in a contract we have some mechanism for breach, which means forfeiture of deposit, or we can affirm the contract and sue for damages, or terminate and sue for damages as well. Now, I mentioned earlier the article by Thomas Word, which is excellent. It's possibly even bettered by the article by MacDonald. I'm just going again to now share that article with you, and I want to encourage you to read this article. It is excellent, but allow me, if I may, to identify some highlights. Once again, starting with the introduction, this opening paragraph is, for me, excellent. And if you can write like this in your opening paragraph in work that you present to me, you can almost see the smile on my face as I get to the end of the paragraph. So here's what MacDonald says. I hate legalese because it forces me to study. I like good prose because it allows me to read. Study tires me out, reading can be a pleasure. The best writing, and legal writing is no exception, allows readers to read and does not require them to study. I'm eager to do anything I can to encourage more reading and less study. So, I'm exposing the 10 worst faults I see in drafting contracts. So that's the dual purpose here in identifying that is to say, that's great writing in my view, and let's think about the 10 worst things that you can do when drafting contracts. Number one is the use of words like witnesseth and whereas. They have no legal meaning, but we used to see them so often, and you probably still will if you're looking at older documents. And please don't draft documents using this type of wording. So MacDonald says that these words were a holdover from the 13th century and beyond. And they persisted for century after century. He says, and I agree with this, out of ignorance and fear. But lest I project my own shortcomings onto others, I will speak for myself on this point. So I can supplement what MacDonald is saying. Because when I first came into law, we saw a lot of this, and I was like the writer, unable to understand why we wrote like this. So that's part of my reason for advancing the use of plain English, as many of us are. So he says, for years, I myself used these terms out of ignorance and fear. I was too uninformed to know that they lacked legal effect. I was too timid to delete them for fear of violating some time-honoured legal principle. After all, those words appear in legal forms and form books nationwide. So they must have some legal magic, right? Wrong. These words clutter documents, they abuse readers. Just as a cluttered room abuses the senses, a cluttered document abuses the mind. That's so well written. He then goes on to say, I also see words like herein, hereinafter, thereof, and whereupon in contracts and leases all the time. Herein is a vague word. This is where it's important because he says, the reader can rarely be certain whether it means in this subsection, in this section, or in this document. So writing ambiguity in contracts is client abuse, colleague abuse, judge abuse, and bad public service. Precision is better. Number 2, one of my bugbears, writing in the passive voice rather than the active voice. The active voice has a clear subject that makes the action in the sentence happen. It is focused, it is definite, it forces writers to commit to what they are writing and readers reap the benefit. Number 3, agreeing too much. Contracts should not start with this agreement entered into, then say, it is therefore agreed as follows, and then repeatedly say, it is agreed, or it is further agreed, or it is expressly agreed. So all of these agree phrases clutter documents with redundancy. Now the author hasn't expressed this in the material, but if I could just add this. If you start to draft in this fashion, then one wonders whether your intention is to change the meaning or to change the emphasis. So if in paragraph 1 you say, I agree, and then in paragraph you say, I expressly agree, is that intended to mean that there's some greater emphasis to be placed on the process of agreeing in paragraph 2 compared to paragraph 1? And you can understand this might be the sort of thing that your opponent would attack your client in cross-examination in a trial. Questions like, so at one stage you agreed, at another stage you expressly agreed. You agree? Yes. So therefore the express agreement was more important than the bare agreement. Is that correct? Well, I don't know. So you don't know what's in your own document, you know. And also, where does it stop? I mean, if you wish to further emphasize the fact of the agreement, then should you draft a clause that says it is really, really, truly expressly agreed? Is that where we go? Let's avoid all of that and let's just draft material correctly and accurately. MacDonald then goes on to talk about opening badly. And the example there, I see, or the statement, I see a lot of, know all men by these presents. It's outdated clutter, and that's the way we used to write. Making a cesspool of words, phrases, sentences, and paragraphs. And he says, not long ago, I read an unintelligible paragraph in a bond form. It jammed words, thoughts, and sentences together in a stream of consciousness jumble. No matter how many times I read it, I couldn't make sense of it, and the thought crossed my mind that its author had had a nip or two before dictating it. Not all writing can be as simple as see, spot, run, but simplicity is a good start. Simplicity is a primary goal, and there are many ways to achieve it. Write to essence, don't be wordy. Group sentences in paragraph around one idea. If a sentence does not relate to a paragraph's idea, start a new paragraph. Small paragraphs are better than big ones because the brain is most efficient at taking in new information in small pieces. Then he goes on to talk about poor structure. Good documents go right along with simple word choices, sentences, and paragraphs. The author then talks about, I'm sorry for flicking through so quickly, he then talks about fearing graphics. And the one that I didn't agree with was loading a document with definition. So I bypassed that. But fearing graphics, and the author says, a picture paints 1,000 words and other graphics can do that too. I received a proposed contract that rambled on for 3 paragraphs about insurance coverages. The more I looked at it, the more I realised that a table would be more concise and easier to read. So I created a simple table, 2 columns and expandable rows. Now I need to be careful here because I've often said I'm not a great fan of long lists. So take that in mind. But where you have a table, and we're seeing this a lot in modern drafting and statutes, it can really help. Thank you for your patience, and the good news is we're almost finished, because once I get to the end of this article, that's it for this evening in the unit. So just a couple more things. Number 9, avoiding cross-references. Cross-references interrupt the document's flow. By using too many of them, it treats readers like a pinball. Eliminate cross-referencing if possible, and minimize them in every other case. Number 10, now bear in mind this article was written in about 1980, so it talks about word processors. Read that now as PCs or Macs. But word processors have a lot to offer legal writers. They have an automatic table of contents, styles, cut and paste functions, tables, dynamic cross-reference capabilities, and so on. Not only can these features make legal drafting more efficient, but also save legal writers from making material errors. I see a lot of contracts without table of content. That should not be, except possibly in short contracts. Preparing a table of contracts is a breeze, and that's true. And then in conclusion, and I like this as a conclusion, whereas the foregoing witnesses the pitfalls herein of legalese as aforesaid, the end of the matter is thus, write plainly. So we could take this unit as being described in those 2 words, write plainly. That brings us then to the end of week 12, brings us to the end of the unit. Do we have any questions, comments? Are we all good? And again, thank you for your patience. All good? All right. Well, thank you for your attendance this term. If you haven't already had your say, please do so. I see that we only have 11 in our cohort. 5 have already had their say. I need to get 50%, frankly, so I need 1 more. So if you're watching this as a recorded session, you haven't pushed the big red button to have your say, please do so. The university needs it. I'd appreciate it. All the best. Thank you very much for your patience, and I'll get the feedback to you as quickly as I can. All the best, and we'll see you next time. Bye then.